Imagine waking up one morning to find the president, without a single vote in Congress, slapping new costs on almost everything you buy, from phones to peanut butter, all under the banner of an emergency. That's exactly what happened, and last week a federal appeals court stepped in and said, enough. A few weeks back, I covered the cases dealing with President Trump's Liberation Day tariffs, and boy did that video get me some hate mail. I guess that's what happens when you point out an uncomfortable truth. Presidents can play king when it comes to immigration, but when they try the same approach in economic policy, the Constitution doesn't afford the same authority. I've been saying all along that the executive has sweeping powers on immigration, but not on tariffs, and well, turns out I was right. In late August, the U.S. Court of Appeals for the Federal Circuit, in an en banc ruling, declared that President Trump overstepped his authority by using the International Emergency Economic Powers Act, IEEPA, to impose broad, long-term tariffs. In V.O.S. Selections, Inc. versus United States, the court affirmed that IEEPA does not give the president a blank check to rewrite tariff policy. Why? Because the Constitution grants Congress, not the president, the power to impose taxes and tariffs. The Federal Circuit judges emphasize that under our Constitution, tariffs are squarely Congress's job, found in Article I's taxing and commerce powers. IEEPA, enacted in 1977, lets the president address unusual and extraordinary threats in a national emergency. In my last video about this, I explained this means things like targeted sanctions or freezing assets in a real crisis. But it was never intended to let a president single-handedly slap tariffs on nearly all imports for the long haul. President Trump issued a series of executive orders to enact his Liberation Day tariffs, declaring a national economic emergency due to trade deficits, and even because of the flow of drugs, then hit almost every trading partner with tariffs, 10% on nearly all imports, higher on some countries. The appeals court agreed with a lower trade court that this scheme exceeded any authority granted under IEEPA. While IEEPA does allow a president to regulate imports in an emergency, the judges said Congress did not silently transfer its core tariff powers over to the president. By interpreting IEEPA narrowly, the court avoided a constitutional collision. It essentially said IEEPA just doesn't cover what Trump tried to do. The judges also pointed out that Congress had provided other, much narrower tariff tools for emergencies he could have used. For example, Section 122 of the Trade Act of 1974 lets a president impose at most a 15% tariff for 150 days to deal with a balance of payments crisis. Beyond statutory text, the decision sounded an alarm about presidential overreach. The judges, including several Republican-appointed judges, recognized the danger in a president unilaterally taxing Americans by tariffs without Congress. In an influential amicus brief, prominent legal scholars from the left and right warned the powers to tax, to regulate commerce, and to shape the nation's economic course must remain with Congress. They cannot drift silently into the hands of the president through creative readings of statutes never meant to grant such authority. That conviction is not partisan. It is constitutional. In oral arguments, one judge even asked whether, if Trump's theory held, a president could declare a peanut butter emergency to tariff peanut butter imports, a tongue-in-cheek hypothetical that underscores the slippery slope. The Federal Circuit's ruling forcefully drew a line. No, a president just can't declare any economic issue an emergency and tax at will. Stepping back, this makes sense from a policy perspective too. Would you want your least favorite president to have this kind of power? Probably not. How did we get to the point where a president could even attempt such sweeping tariffs on his own? Over the 20th century, Congress gradually delegated more trade and tariff authority to the executive branch, often to deal with emergencies or foreign trade disputes. The Constitution is explicit that Congress controls tariffs and foreign commerce, but Congress has long enacted statutes letting presidents adjust tariffs in specific scenarios. Courts traditionally upheld these delegations, finding they weren't an unconstitutional surrender of legislative power. Let's look at some key episodes and laws that expanded presidential tariff powers. 1930s. In response to the tariff chaos of the Great Depression, Congress shifted strategy. The Reciprocal Trade Agreements Act of 1934 allowed President Franklin D. Roosevelt to negotiate bilateral tariff reductions up to a certain amount without returning to Congress each time. Cold War and security tariffs, Section 232 of the Trade Expansion Act of 1962 let the president impose tariffs or quotas if an import is threatening national security. The law requires an investigation by the Commerce Department first to find if something is being imported in such a way that it might weaken the U.S. defense industrial base. This was meant as a narrow tool. In the 1970s, President Nixon used Section 232 to put quotas and fees on imported oil amid energy security worries. The Supreme Court in 1976 upheld Section 232's constitutionality in Federal Energy Administration versus Algonquin, noting it had clear preconditions before the president could act. The Trade Act of 1974 and new tools. In 1974, Congress passed some flexible tariff provisions. Section 201, safeguards, allows the president to impose temporary tariffs or quotas if a surge of imports is seriously injuring a U.S. industry. This is like a pressure release valve for industries hit by import competition. President Reagan in 1983 used Section 201 to impose a 45% tariff on imported motorcycles to save Harley-Davidson. President George W. Bush used Section 201 to tariff imported steel in 2002, following dozens of bankruptcies by U.S. steelmakers. There's Section 301, Trade Enforcement, Unfair Practices. This authorizes the U.S. Trade Representative to retaliate against other countries' unfair trade practices or violations of trade agreements. In the 1980s, Reagan used Section 301 as a big stick, threatening and sometimes imposing tariffs on Japanese electronics and European goods to press for better trade terms. President Obama relied more on WTO cases than unilateral Section 301, but he did use it occasionally. For instance, in 2010, the U.S. threatened 301 action over Chinese green technology subsidies. President Trump turbocharged Section 301 in 2018 and 2019 by slapping tariffs on hundreds of billions of dollars of Chinese imports in response to China's intellectual property theft and trade abuses. There's Section 122, emergency tariffs for balance of payments. In August of 1971, President Nixon imposed a 10% surcharge on all imports to protect the U.S. dollar and fix a balance of payments crisis. In 1974, learning from that, Congress included Section 122 to give a president a limited version of such power. It allows an emergency tariff up to 15% for no more than 150 days to deal with international monetary crises or large balance of payments deficits. The court in the Trump tariffs case specifically referenced Section 122 to underscore that if Trump wanted to address trade deficits as an emergency, he should have been bound by those statutory limits. Then there's the Trading with the Enemy Act, TWEA, and IEEPA, as we've discussed. Earlier, TWEA of 1917 gave presidents broad power to regulate economic transactions during war, originally World War I. And later this was used even in peacetime emergencies until 1977. IEEPA was passed in 1977 as a reform. It transferred peacetime emergency economic powers to a new law requiring the president to declare a national emergency and subject to some congressional oversight. President Jimmy Carter froze Iranian assets and embargoed trade with Iran in 1979 using IEEPA during the Iran hostage crisis. President Ronald Reagan used IEEPA to sanction regimes like apartheid South Africa and Nicaragua. President Obama invoked IEEPA to sanction Russian officials and entities after the 2014 Crimea invasion. But those actions were focused, aimed at specific bad actors or narrow categories of goods, not blanket tariffs on all trading partners. Throughout these developments, the judiciary mostly stood on the sidelines. Challenges to presidential trade actions have had a tough time succeeding. Courts frequently stated that as long as Congress outlined some conditions of delegation to the executive, the delegation was permissible. For instance, when Trump's steel tariffs were challenged in 2018 and 2019, the courts upheld them. That's why the recent Trump tariff ruling is so striking. It indicates a potential shift in how courts view broad delegations of trade power. It also signals that Trump's tariff move may be different in kind from what other presidents have done. The judges explicitly invoked the Supreme Court's major questions doctrine, a newer judicial principle saying courts should not assume Congress authorized a major transformative policy in general language. They also signaled that limitless delegations might flunk the non-delegation doctrine if taken to extremes. The Trump administration's aggressive use of every available tariff power is really testing these legal boundaries. In summary, by 2025, the pendulum of tariff authority had swung far toward the president, far enough that a president felt emboldened to declare an economic emergency and tariff the world. The Federal Circuit's ruling suggests that pendulum might be swinging back towards Congress, consistent with constitutional design. With this tension, what are the broader policy implications? This case strikes at a core constitutional question. Who should control the nation's economic levers, and how much power is too much for one person in a republic? Limited government, separation of powers, and free trade are values often espoused by conservatives and libertarians. The Constitution's framers deliberately gave Congress the power of the purse and the power to set tariffs, precisely to avoid an overmighty executive acting like an unchecked monarch. As originalist scholars note, British kings used to wield trade taxes as a personal tool, something the American revolutionaries rebelled against. The founders wanted taxation with representation, which means tariffs, a form of tax, should be decided by the legislative branch that's closest to the people. The policy implications go beyond Trump. Picture the person you least trust making weighty tariff and trade calls. Today, Republicans might celebrate a GOP president imposing tariffs to protect factories or coal workers, but tomorrow a progressive president could declare a climate emergency, inciting some broad law, slap massive carbon tariffs without congressional approval. Would conservatives accept that? Tariff authority in a single executive is a double-edged sword. It might achieve certain policy goals quickly, but it sidesteps the deliberation and compromise of Congress, and it can swing wildly with each administration's whims. That instability can be bad for business and consumers, and it undermines our constitutional structure. From a free trade and classical liberal stance, tariffs are generally seen as self-harm, burning down your house to smoke out a mouse. They invite retaliation and usually get paid by consumers. Allowing one person to impose them at will compounds the concern. And from an originalist constitutionalist angle, it doesn't matter if it's President Trump or President Obama. The founders would frown at the approach. James Madison didn't envision an elected king setting trade policy solo. He envisioned an executive carrying out the laws Congress writes. The recent court decision reflects a resurgence of these concerns. With the Supreme Court ruling that IEEPA did not clearly authorize across-the-board tariffs, the court reinforced the principle that big policy moves need democratic, in other words, congressional sanction, not just an emergency declaration. This hews closely to originalist sentiments. It reins in the imperial presidency in favor of the Constitution's separation of powers. In closing, the judiciary is reminding us of something the founders knew well. Concentrated power is dangerous, no matter who wields it. Tariffs may seem like just another policy lever, but in constitutional terms, they are a form of taxation. If we hand that power to a single executive under the vague banner of emergency, we're not living in a republic of laws, but in a system where economic policy can swing on the will of just one person. Today, it might be tariffs for trade deficits. Tomorrow, it could be carbon taxes by decree or sweeping import bans in the name of protecting the climate. That's why this ruling matters. It recenters Congress in its rightful place and reins in the creeping idea of an elected economic monarch. In a system built on checks and balances, the message is simple. No president gets to be king of Commerce. I'm Benjamin Barr, and I'm thankful you were here with us today. My job as a constitutional litigator is to give you the tools necessary to resolve today's constitutional controversies. I hope you'll take a moment to like and subscribe on this video as it helps our educational project. Please join us next week as we unravel yet another constitutional controversy.